Hello, it's Eric and Steve from Rains Feldman, bringing you the latest installment of the thrilling and exciting Rains Feldman Cyber Liability Report. I have just returned from Ann Arbor, Michigan, and witnessed a Michigan Wolverines victory over the Wisconsin Badgers. And so, in tribute to my Michigan trip, today, Steve, we want to discuss a trademark case coming out of the Eastern District of Michigan. And it's a case involving trucking companies, I think. The parties are, it's like an alphabet soup of companies, but we'll call it XPO versus R&L carriers. And we've been talking a lot lately about trade secrets cases and litigation and unfair competition, and I think this case is interesting because it shows a creative way that competitors try to keep their competitive advantage and use trademark law and the Lanham Act to bring litigation against a competitor and maybe scare a competitor away from either obtaining market share or obtaining employees. So Steve, why don't you give us the quick factual background here, and then we'll ask you for your expert opinion of how the case came out and what it might mean for our clientele.
So the case concerns XPO, like you said, and R&L, and a third carrier company called Conway. XPO bought Conway, acquired Conway. About the same time that happened, their competitor R&L decided to put up an advertisement on the web at a web address called conwaylayoff.com, basically reaching out to the existing Conway employees saying, hey, if there's a layoff, we're hiring. They use the name of Conway in the website address, conwaylayoff.com. They use Conway's name on the website saying Conway has been acquired. If you're a victim of a layoff from them, we're here and we're hiring. We're a great company.
Okay, so XPO gets pissed off and files a lawsuit. What are their legal claims?
Their lead claims first was for trademark infringement, saying we own the Conway name. You can't use it in a commercial way to try and advertise your business. And the second is a cyber squatting claim under the federal anti-cyber squatting statute.
Okay, so let's start with the second claim first, the cyber squatting. So typically on cyber squatting, when we see cyber squatting claims, one of the main elements there is bad faith, right? And so the plaintiff would have to show that the defendant registered a domain in bad faith in addition to it infringing a mark in some way. So and typically the bad faith is someone who isn't engaged in business, just snapping up domains, and they want to extract some sort of exorbitant purchase fee. But that's not what's going on here, correct?
Right, you're right. The typical cyber piracy, the cyber squatting case is somebody buying McDonald's.com who doesn't own a burger shop but wants to sell it to McDonald's to make money off of just owning the name. Here, they used a website address called conwaylayoff.com, so it's not exactly the name of their competitor. And the court found no bad faith because they didn't do any of the typical cyber squatting things like trying to sell it, just parking it and not using it. They actually used it for advertisements. So
they're trying to attract potential employees that may or may not be laid off by Conway. So, okay, that sounds like a pretty easy, non-controversial decision. What about, you said the first claim was just straight up trademark infringement, correct? And so my question to you is, right off the bat, I'll start with my trademark infringement analysis with, the fundamental standard, which is likelihood of consumer confusion.
Right.
So when I read this fact scenario right off the bat, I say, well, this isn't confusing any consumers. They're not trying to play themselves off as as Conway. I don't think anyone would think that if Conway were laying people off that they would be publicizing it, although, maybe Conway would have a website to help employees laid off, but it just doesn't upfront fit the common confusion scenario in my head. So how did the court address that?
So the court in this case did sort of a similar analysis. It went through the steps in the Sixth Circuit, which is where Michigan's located in the federal system, to look at a trademark claim. The first thing for a trademark claim there is the use commercial? And it's a very, very low bar to get over. And in this case, the only reason they did was on the page, in addition to saying we're hiring employees, at the very end of the page, R&L also said, here's a link to our website to learn about our services.
I see. Well, that is a low bar, and I can see that bar being met here, but that wasn't enough to prevail on their claims. And
No.
why is that?
So then the court goes to the next step and says, in the Sixth Circuit, we look and see whether or not they're using the mark in a trademark way. And that's sort of a shorthand for exactly what you're saying. Are they using it in a way to describe their own goods and services that they're providing in a way that might be confusing? Here, the court reaches that question and says, no, they're absolutely not using it to describe their own services. They're describing their competitor and saying that they're different from their competitor and that they're a place where their competitors' employees can come and maybe find a job.
Yeah, I mean, it's not even trying to steal their employees. It's really, if you're laid off, here's a place where you can continue with the job.
Right, exactly. So, having failed at the second step, the court didn't get to the next step of likelihood of confusion. Didn't even need to go there to that point, and decided at this early stage, let me tell you that, this is before any discoveries happen. This is just after the pleadings have been filed. The defendant, R&L, filed a motion for judgment on the pleadings saying, even if you assume everything in their complaint is true, they don't have a claim.
Okay, well, that's important to get the procedural posture. So what was nice for R&L, the defendant here, is they didn't have to engage in costly discovery and consumer surveys and hire experts. So that's a good strategy for someone in a similar position. Now, one thing that I wanted to ask you, we've dealt with similar scenarios here in California in the Ninth Circuit, and we have the nominative use doctrine. Isn't this pretty much essentially the same type of a nominative use analysis without actually using the name? Because for whatever reason, the Sixth Circuit hasn't adopted the nomenclature of nominative use. Is that correct?
Yeah, that's exactly right. It's the same result, same sort of idea, just not using the nominative fair use test, which, if you're familiar in Ninth Circuit, so California and the West Coast, if you're using the name to actually call your competitors' products what they are, say, compare me to.
It's kind of like the Pepsi, the soda wars,
Yeah.
the taste, the blind taste tests, the commercials you used to see with beers and sodas. Hey, Coke and Pepsi, let's see which one tastes better.
Yeah, and the other kind of scenario for nominative fair use is something like surveys or questions or ride-along things. There's a famous case where there was a newspaper 900 numbers dial-in survey about the Backstreet Boys, and you couldn't talk about the Backstreet Boys without using their trademark name. So that's a nominative fair use. You're not saying we're the Backstreet Boys. You're saying we want to talk about the Backstreet Boys.
Right. So that's an important concept, I guess, for us to close on for the layperson out there. I think people often get trademark and copyright confused, and sometimes people are of the belief that you cannot use a trademark in discussion, that it's verboten, but you can talk. A company has trademarked their name. That doesn't mean you can't criticize them. That doesn't mean you can't compare your services to them. That doesn't mean you can't use their trademark to compete with them. And so I think that's the takeaway from R&L Carriers as applied to a domain name and a website. And it shows how you can compete online with a competitor in a fair way. And are there any other takeaways from this? I think it's pretty straightforward. I think I agree with the conclusion of the court, and I think it's good news for people who want to compete with competitors and go after talented employees in a scenario like this.
Yeah, I think it's absolutely right, straightforward, and it's, even though they didn't use the kind of nomenclature we might see out here, because of whatever reasons they have in the Sixth Circuit, they were able to get to the result that seems to make the most sense in trademark.
All right, well, that's it for this week. This was the Michigan Trademark edition of the Cyber Liability Update. We'll see you next time.